This podcast is for educational and informational purposes only. It is not medical advice, legal advice, or professional advice of any kind. And it does not create an attorney-client, physician-patient, or other professional relationship. Any discussion of cases, outcomes, standards of care, statutes, or regulations is general in nature, may be incomplete, and may vary by jurisdiction and over time. Listeners should consult their own attorney, malpractice carrier, risk manager, or qualified clinician for advice on any specific matter. Any case discussions are based on public records, de-identified information, or educational reconstruction. The views expressed are those of the speakers and do not necessarily reflect the views of any employer, hospital, health system, insurer, or affiliated organization. Welcome to a special free preview of On the Record Season 2 from the Charted Defense. In this series, we take a real medical malpractice case and break it apart. From the patient's initial presentation, through the clinical decisions, and into the courtroom. Everything you're about to hear is based on public court filings, appellate decisions, and the litigation record. We have anonymized certain details to protect privacy while preserving the educational value of the case. This is not legal or medical advice. If you followed Season 1, you know how we do this. We go step by step, the medicine, the law, the human cost. Season 1 examined a pressure injury case involving a critically ill patient who developed a Stage 4 wound during a 3-month hospitalization. That case was ultimately dismissed on summary judgment before trial. Season 2 is a fundamentally different kind of case. It's not about what happened during a single hospitalization. It's about a prescribing decision and what unfolded over the months and years that followed. At the center of this case was a young woman, a wife and mother. She presented with bilateral pulmonary emboli, clots in both lungs at a young age. She survived. But the question her doctors needed to answer was, why did this happen? The workup that followed revealed a complex and dangerous clotting profile. She had inherited gene mutations that independently increased her thrombotic risk. More critically, her blood tests showed evidence of antiphospholipid antibodies, markers pointing toward a diagnosis of antiphospholipid syndrome, or APS. APS is an autoimmune condition in which antibodies attack proteins involved in blood clotting, paradoxically making the blood far more prone to forming dangerous clots.
A PS is the diagnosis that drives this entire case. And what makes it so important for physicians to understand is that APS has very specific treatment requirements. The medical literature is clear. Warfarin, a vitamin K antagonist that blocks multiple points in the clotting cascade, is the established treatment. You cannot simply substitute any blood thinner and expect the same result. This is not a situation where newer automatically means better.
The patient was initially managed on warfarin and enoxaparin. But according to the allegations in the lawsuit that followed, at some point during the course of her care, a critical prescribing decision was made. The complaint alleges that one or more of her treating physicians switched her anticoagulation from warfarin to rivaroxaban, a direct oral anticoagulant, or DOAC. And that decision, the plaintiff argued, set off a chain of events that led to her death. To understand why that prescribing decision matters, you need to understand the science. DOACs, like rivaroxaban, target a single clotting factor, factor 10A. In most patients with atrial fibrillation or routine venous thromboembolism, DOACs work well. They offer fixed dosing, no INR monitoring, fewer drug interactions. They were adopted rapidly across medicine. By the mid-2000s, case reports were emerging of APS patients switched from warfarin to to DOACs, who then suffered new thrombotic events. Professional societies were issuing cautionary guidance, and eventually, a randomized controlled trial called TRAPS directly compared rivaroxaban to warfarin in high-risk APS patients. The trial was stopped early because the patients on rivaroxaban were experiencing significantly more thrombotic events. Approximately a year and a half after her initial pulmonary embolism, the patient was admitted to the hospital. The hospitalization lasted several weeks. During that time, the complaint alleges that even the inpatient treatment was deficient, that anticoagulation management remained inadequate, and that the discharge plan failed to properly address her ongoing needs. After discharge, the patient's condition continued to decline. Within a few months, a healthcare proxy was filed. The patient passed away later that year. She left behind her spouse and children. The exact date of her death is not recorded in the publicly available court filings. Several months after her death, a medical malpractice lawsuit was filed. The verified complaint named 7 defendants across 3 separate healthcare systems, individual physicians, and the institutions that employed them. The allegations span the full arc of the patient's care, from the initial diagnosis of APS, through the prescribing decisions, through the hospitalization, and through discharge. The complaint laid out 10 specific departures from the standard of care. They alleged failures to diagnose and treat APS, failures in prescribing the wrong anticoagulant, failures in monitoring, failures in bridging therapy, failures in specialist referral and communication, and failures in discharge planning. 7 defendants, 3 healthcare systems, 10 allegations, 1 patient.
When you have that many providers named across that many systems, the case becomes structurally complex. Each defendant is judged on their own conduct, their own duty, their own alleged breach, their own causal contribution. But the pattern itself becomes part of the story. When multiple providers across multiple systems allegedly got the same thing wrong, it raises questions about whether anyone was looking at the whole picture.
What followed was years of litigation. The case reached a significant legal milestone in early 2026. 2 groups of defendants moved for summary judgment, asking the court to dismiss the claims without a trial. They submitted expert hematologists who argued that prescribing a DOAC to this patient did not depart from the standard of care, and that even if it did, the departure was not the proximate cause of the patient's injuries. The court used a phrase that matters in litigation: dueling expert opinions. When 2 qualified experts offered directly conflicting evidence-based opinions on the standard of care and causation, a judge does not pick a winner. A jury does. That is why the case survived.
There's a lesson there for every physician. The court also addressed an argument the defense made, that medical literature shouldn't define the legal standard of care. The court agreed with that general principle, but it said the plaintiff wasn't arguing that a study is the law. The plaintiff was arguing that a reasonable physician should have evaluated the available literature more critically before choosing this drug for this patient. That distinction between the literature is the standard and a reasonable doctor would have read the literature differently is the legal territory physicians need to understand.
It is possible this case settled. Many medical malpractice cases do settle after surviving summary judgment. The appellate court's ruling that a jury should hear the evidence can change the calculus for both sides. But we do not have confirmation of the final resolution.
Regardless of how the case resolved, the lessons are already clear, and that's what Season 2 is about. Not assigning blame to these physicians. I wasn't in those exam rooms, and I don't have the full medical record. but identifying the patterns, the decision points, the places where the cascade might have been interrupted, that's what makes this educational.
During the three-part season, we will dig into the medical condition, the complaint, and the medical experts that each side brought in and what those positions were. There are a few talking points in this reason we will discuss further, such as informed consent and the process of shared decision-making.
I hope you'll join us for the full season. Subscribe to the Charted Defense on Substack to get access to the complete 5-episode series and our accompanying written deep dives.
Thanks for listening to this preview of On the Record Season 2 from the Charted Defense. We'll see you in Episode 1.